morning, Your Honors. The matter before the court this morning is the case entitled In Re Investigation to Review the Avoided Costs that Serve as Prices for the Standard Offer Program in 2019, docket number 2019-393. Representing the appellants, Allco Renewable Energy Limited and PLH LLC, is Thomas Melone. Representing the appellee, the Department of Public Service, is Alexander Wing.
Thank you very much. Counsel for the appellant, would you introduce yourself, identify your client, and then proceed with argument, please?
Yes, Your Honor. Good morning, Your Honors. My name is Tom Melone. I'm counsel for PLH LLC and Allco Renewable Energy Limited. The basic question in this case is whether the state entity that issues a request for proposals is bound to adhere to the express and material terms of that RFP when reviewing bids submitted in response to the RFP. If the answer to that question is no, then the PUC was able to do as they did, which was award a contract to whoever they wanted. If the answer to that question is yes, then the state entity must follow the terms of its RFP, and the PUC must be reversed and the challenged awards retracted. No one ever contests higher price non-conforming bids. The RFP in this case had very few requirements. The basic requirement is that the bidder must have shown site control. And such site control must have been in favor of the proponent's legal company name. That's shown at printed case pages 55 and 56, RFP section 3.13. Site control as defined for the RFP means proof of dominion over real property to the extent necessary to construct the project. That's at printed case page 30. Site control expressly can be established in only one of four ways. Three of the awards at issue here did not establish site control in one of those four ways, but rather tried to create a fifth way. Two of those same awards also did not have the needed land rights to construct and operate the projects. Those sites, those projects were landlocked with easements only for residential and farming purposes. Now, if the bidder showed up with a land purchase contract for a site and that contract was not signed, it would be clear that the bidder did not satisfy the site control requirements at the time of the bid. Indeed, the PUC has disqualified bids that submitted such unsigned contracts by the bid date, even if that same bidder showed up a couple days later with a signed contract. The situation here is the same. An unsigned contract for site control is the functional equivalent of a signed contract that does not provide the necessary land rights. In both cases, the bidder does not have the necessary land rights at the time of the bid, and that's the key thing.
So one of the things I was trying to sort through is, site control is not defined in the regs or the statute or anything. I understand your position is that site control includes not only control over the physical site on which something is going to be constructed, but also sufficient access rights to get there for the purpose of building that. Am I right that that's your understanding of the scope of site control?
That's correct, Your Honor. And while site control itself, that term is not defined in the RFP, it is defined in the power purchase agreement that accompanies the RFP. And that is what provides proof of dominion and control over real property necessary to construct and operate the project. And the PUC has yes. Go ahead.
Could you just explain to me as best you can the argument that you made in your brief regarding judicial deference on that issue, on the property rights issue?
Sure. On the property rights issue, the PUC doesn't have any expertise in property rights. I mean, this court does. So there isn't any reason to provide any deference to the PUC on whether a deed or an easement provides necessary control in order to build and access the projects. I mean, the PUC itself, in a way, declined the responsibility to review the actual legal deed restrictions and said, well, it's not up to us to decide one way or the other. We're going to award the contract, and if they don't have the land rights, they don't have the land rights. But that's not
They were
what they're
interpreting.
The PUC also said that that would result in a forfeiture of the deposit, correct?
That's correct. So if they couldn't actually build the project, but that puts us back to the same circumstance where somebody shows up with an unsigned contract and says, well, but they're going to sign it. There's really no difference. At the time of the bid, they didn't have the land rights. So if it turns out they get the land rights later, or say they had land rights, but they don't have them all,
Doesn't the PUC, doesn't the PUC only need to make a finding that the proposal is reasonably likely to achieve commissioning? And so what standard should the PUC be using? It's likely they'll get access, it's not likely they'll get access, or is it some other standard?
Under the statute, they certainly didn't have to create the RFP that they did. So they could have said people can submit bids and we'll make some decision as to who we think is likely to achieve commissioning. That would be something that they would have had the right to do in the statute. But here, they establish an RFP. So the question is, do they have to follow the RFP? Because when they issue the RFP, the bidders, like us, read the RFP and go to expense to follow the terms of the RFP. So that means we have to go try to select sites where we do have the land rights. And that creates a higher cost, that creates a higher cost. So that's the real question. If the PUC is not bound by the RFP that it issues, then of course they can make whatever determination they want.
Are you, may I ask you a question, Council? Are you saying that there's a higher standard than what Justice Carroll just referred to? Because I'm looking at 8005AH, and that is the standard that's expressed in the statute itself under the heading of application process. Are you suggesting that the RFP set a different or a higher standard than what is expressed in the statute?
Yes, it did. Because the statute itself specifically says the PUC is supposed to create the program and can create the program's rules by an order, by issuing regs or some other means. So they did that. They did that by issuing the terms of the RFP. And in prior years,
What portion of the RFP is inconsistent with that statutory language? I still don't understand.
the RFP is not inconsistent with the statutory language. We're not arguing that. We're just saying that once an agency issues rules under the statute, and we're not disputing that the RFP terms are inconsistent. We're just saying that once they issue those rules, an agency should follow the rules. That's all.
Doesn't the agency get to interpret the rules? Or in 3.1.3, that they interpreted the rule to say that there was site control requirements had been met?
Well, they get to interpret the rules if there's some ambiguity in the rules. But their rules here are clear what the requirements are. And I think the PUC conceded that at the end, they were basically just ignoring it by saying, well, even if we aren't going to decide whether they had the necessary land rights, so they didn't make the decision as to whether or not there was, in fact, site control. But if they don't have them, then they lose their deposit. So in a way, they didn't even make a decision on site control. They refused to, but their rules are clear in the RFP. And in prior years, they disallowed bids for the same reason that we're arguing these contracts should be disallowed, or these bids should be disallowed. Because the party didn't have the rights, all the rights needed to access the project and to build the project. So the bidder itself didn't dispute that they didn't have the land rights. All they said was that we'll be able to get the bidding rights by easement by necessity. And the PUC said they weren't going to decide that issue either. But they didn't have the easement at the time of the bid, and that's really the test, whether they had the land rights at the time of the bid.
If that's the argument, well, we're going to get an easement by necessity, doesn't that effectively gut the site control portion of the RFP?
It does gut the site control part of the RFP, and it also would gut any kind of restrictions on land use in the state of Vermont, because if they're saying they're going to get an easement by necessity to build a commercial project, you know, the land is as it is now restricted to agricultural use, and the PUC is right here, or if this court rules in favor of the PUC, and any agricultural easement can be overturned based on the same argument.
So what if the facts are slightly different, which is that there's a deeded easement, and one could argue about whether the scope of the easement accommodates the use that will be required for the access. In that situation, is the board or actually it's the facilitator who's making recommendations to the board required to conduct a legal analysis and make a legal determination about whether the scope of that easement is or is not in fact compatible with the needs of the project?
Yeah, I do believe they are, Your Honor, because they're the ones that established the site control criteria in the first place. They certainly make that determination when somebody shows up with an unsigned contract. They say, well, we know that an unsigned contract doesn't give you site control. We're not sure maybe where the gray line is between all these rights that you have, but we know certain. But they do make that determination. Here, they just didn't make the determination.
How do we avoid, I'm just trying to think about, and your line is a nice clean one, which is it sounds like any challenge to the validity of the rights asserted needs to be resolved before they start picking sites. Is that your argument, or is there some line that says no? At some point, we're not going to turn this bidding process into a mini trial within a bidding process on a complex and highly contested issue about access, or even building rights for that matter.
Yeah, I mean, the easiest thing is what we do is it's clear that we have site control. Now, I guess to the extent an issue is raised on site control, I think the PUC, because they've established the definition of what site control is for purposes of the RFP, they have to make the determination as to whether what's being offered in terms of rights satisfies the definition they created. And here they didn't, and I think they never claimed, and the bidder never claimed that the rights were there. All they said was they could get the rights by easement by necessity, which I think this court would realize is not the case in this circumstance, because all they're trying to do is build a commercial facility on agriculturally restricted land.
It seems odd to me that you just recognized a few minutes ago that the PUC has no expertise in these types of land issues, like determining whether there's an easement. So why would we want the PUC to have to make those determinations?
Well, I think it's a question of the deference that this court would give. I mean, the PUC is acting as, say, like a trial court here. They have to make the first determination because it's a site control requirement they created. And the question is, well, what type of deference should you give to them? And in this particular case, they don't have any particular deference in determining property rights.
I'm not talking about deference on review. I'm talking about, it sounds like you're advocating that the PUC here should have held a hearing and taken evidence about this easement and whether it would allow for the project to go forward, whether there was a likelihood of an easement by necessity. But you also said that the PUC has no expertise in this, and I'm asking you to reconcile that.
Well, I do think they have to make a determination. right? They don't have any special expertise, but they have to make a determination. And here we pointed to the language of deeds, which are clear, that say the land rights are only for agricultural purposes.
See 1 minute remaining, counsel.
So I'd like to reserve that for rebuttal, if I may, Your Honor.
Okay. All right, we'll hear from counsel for the appellee. Will you introduce yourself, please, and identify your client, and then go ahead with your argument.
Good morning. Thank you, Justices. May it please the Court, I am Alex Wing, and I'm here on behalf of the Department of Public Service. The appellants have raised many arguments in this case, but in deciding them, this Court should consider two main facts. The awarded solar energy generation plant that got contracts here will sell their for between 8 and 9 cents a kilowatt hour. Conversely, the appellant's bids were selling from anywhere between 11.8 cents to 11.9 cents a kilowatt hour. So it's fair to say that's practically 12 cents. Now, when you apply these electric rates to 2.2 megawatt projects with 25-year contracts, that represents a substantial added cost that would be borne by Vermonters. And that is also
Really, aren't there those really two arguments? One is whether or not these folks should have been awarded contracts. The other is whether Mr. Malone should have gotten one, or his clients. Those are really two different issues, aren't they? You're saying, well, his plant's going to cost more money for the electricity that they generate. That doesn't really have anything to do with whether or not these other folks should have gotten an award.
Well, it doesn't bear on whether the other folks should have gotten an award for the RFP. That is true, but it is also a highly relevant fact. And it also bears in consideration to the plain and simple fact here that if the appellants prevail in their argument and the three NextEra projects fail the RFP process for want of site control, and the Still Grove Solar Reserve project fails for using the wrong and otherwise compliant map, these projects were still expensive. You need merely look at the board order to see that there are several other projects ahead of the appellant's projects, and at best, it would have earned a spot as an alternative in the space. They were priced out. They were rejected because of price and not otherwise looked at on the merits.
Wait, I want to understand your first argument, because you're holding firm that it's highly relevant, the relative cost of power from these different applicants. And I'm trying to understand whether your position is that the site control provision in the RFP governs, but the PUC has discretion to essentially waive or put that aside if the relative cheapness of the power makes it willing to take a risk. Is that what that argument boils down to?
That is not what the argument boils down to. In fact, if you look at the board order, two projects were rejected that were cheaper than the appellants because they did not comply with the RFP process. The main point was, by comparison, these projects were rejected because of price. And the projects that the appellant is complaining about were selected for being compliant with the RFP, and they've put forth these arguments that they are not. The RFP only requires site control for the project parcel. The four criteria do not make mention to access, easements, interconnection, or anything of that nature. And these projects were also in the name of wholly owned subsidiaries, intercompany affiliates, very detailed and valid agreements between them. And all that statute requires, sorry, Justice Robbins.
So I want to just this question of whether access is included. On the access issue, is that what you're hanging? There's two different issues that I'm seeing here. One is no, the PUC is not in a position to evaluate the strength of somebody's rights or claims to rights. That argument would apply with equal force whether we're talking about the project parcel itself or access rights. And then the second issue is no access rights are off the table. So is it your position that it turns on the second issue and that you don't even have to show that you have the ability to access the parcel to build the project? And if so, how is that consistent with the description of access of site control as including essentially the bundle of property rights you need to make this project happen?
So that's a complicated question, and my answer is going to seem a little roundabout, but I promise you'll get there. 8005A, Section H, is the standard that the commission is supposed to use, aside from cost, in reviewing the standard offer contracts, and that is making sure that a project is reasonably likely to be commissioned. So this RFP was designed to weed out speculative bidding, people just putting in poorly thought ideas to get their foot on the table, maybe a lower price bid that they couldn't actually deliver on. So the RFP is a creature created by the PUC, and ancillary to their purpose. So they do have some authority insofar as it relates to executing that statutory directive. But there has to be a line because the statutory directive itself is reasonably likely to be commissioned. So very detailed analysis of property rights claims, which are properly vested in the courts. The PUC doesn't need to necessarily sign that because a reasonable likelihood is not a certainty. At some point, a developer has to assume the risks that their project might not come forward. Projects drop out of this all the time. They aren't able to make their deadlines. Justice Eaton.
Can I ask you which of the four means that were set forth in the RFP were met here? I mean, I understand you're making a statutory argument, but in this particular case, there is an RFP drawn up which gives much more detail on the site control. Which one of those criteria did the successful bidders meet?
As I understand it, it was a proper lease to access and build the project. When those four terms are laid out in the RFP, they don't say leasehold, title, things like that, and anything ancillary to project access. At that point, it is kind of the developer's issue. And when a colorable, reasonable argument is put forward that it complies and they've otherwise demonstrated that they access the site, again, through option agreements for their wholly owned subsidiaries, which is very common in solar development. They tend to have LLCs that are purpose-built for a project. Then they've demonstrated that they have site control of it. And the commissioning milestones that are inherent to a standard offer contract are such that these projects are likely being pursued. To my knowledge, they have not dropped out. Given that, is it really fair to unhinge projects that have a reasonable likelihood of being commissioned?
Would it be enough then if they said in their application, well, we haven't really talked to the landowners, but we've heard that they're interested in this kind of an arrangement, and we intend to do that if our project gets approved. Would that be enough?
It wouldn't be by the terms of the RFP. The RFP lays out 4 ways that it needs to be met. And the commission made findings of fact that said that, hey, it met these 4 terms. Reading easements and various access rights is not in the language itself of the RFP.
So your answer to my question was very helpful, but it didn't give me clarity on the question of whether you view access as opposed to control of the parcel itself as something that you need in order to satisfy the RFP's requirement of dominion and control of the property sufficient to build the project, essentially? Is it your position that you don't need any access or to show that you have any access to the property in order to meet the site control requirement?
Well, dominion and control necessary to access a parcel is kind of a slippery slope because, again, it would get to a point where the PUC doesn't really have jurisdiction. I mean, this seems far-fetched, but hypothetically, different access could be made from all sides of the parcel. I wouldn't say that project control is absolutely irrelevant, but there's also a point where that's not the PUC's prerogative or authority because all they're really looking for is a reasonable likelihood of being commissioned. So they've demonstrated control of the site parcel itself, and they've put forth an argument that says, PUC, we have access to the site, we'll take care of it, we have a response to the appellant's claim. And I think at that point, having established dominion of the parcel itself, the PUC has discretion to take that at face value and not probe too deeply into it because that really belongs to the court.
And is the argument that we'll get an easement by necessity one that carries the day?
I mean, that's the argument that they made. The PUC expressly said that they were not going to decide that. So whether it carries the day or not is between the site landowner and the developer.
Did the agreement between the landowner and the developer, I'm not sure I saw it in the record, it might have been there, indicate what the developer intended to do with the property? In other words, that it's for a solar project?
Sorry, I don't have the actual answer to that project. That's my recollection, but I don't know with certainty.
I didn't hear your recollection because you just cut out for a moment. Can you repeat that?
So it's my recollection that it did specify that that was their intention with the land, but I don't know that for certain. And, I mean, the lease was a very long document.
If an applicant submitted a lease to show site control, and the lease covered the project parcel and gave them an license to use the parcel or an easement to use the parcel for any purpose other than that lease and said, here, we have a lease to control this property, would the Commission A be entitled and B be required to look at that lease on its face and say, no, this doesn't actually give you the rights that you're saying it gives you because of that exclusion?
I'm not sure, but I believe they probably would look at that and decide it. But again, they would probably direct the adjudication of those property rights to the Superior Court. They're not actually deciding what the rights are. They're just looking for whether it's reasonably likely to be commissioned. And if something like that is going to be disputed, and I mean, that's much more integral to the project parcel itself, then that would probably mean that it's not reasonably likely to be commissioned in that instance. If I may, with
2 minutes left.
So if I may briefly touch upon some of the other arguments which were brief, but the appellant's legal argument did not largely address. One alternative, because it submitted a project map on 8.5 by 11 paper instead of 24 by 36, but was otherwise compliant. The appellant argues that that's a mandatory RFP requirement, and the commission and the department believe that that is a minor thing because it is otherwise compliant to be waived. The appellant also raises some constitutional arguments, which the PUC does not have the jurisdiction to answer because they are facial arguments and they are ultimately not availing. If there are no further questions, I rest on my brief and thank you for your time.
Okay. Thank you very much. How much time does the appellant have?
Appellant has 30 seconds remaining.
right. Mr. Malone, go ahead, please.
Microphone.
Yeah.
Thank you, Your Honor. So just two quick points. We're not saying that the PUC can't change the terms of its RFP to be more in line with what the words of the statute are. But when they issue an RFP, people rely on it, and they should be able to be held to account for it. And if a bidder shows up with a land document that basically requires all agricultural easements to be overturned in the state of Vermont, to me, that's not a reasonable position. And
Could you, in a very short period of time, explain your constitutional argument? I guess there's no time, so.
Okay.
Very
You want me
briefly.
to respond? Sure. So the provider block just provides, in fact, the provider block has not been shown by even the PUC to have any reasonable basis for why it discriminates in favor of providers. I just heard counsel for the department talk about expensive projects. Well, the provider block that was awarded projects were higher than every other bid that was submitted, yet they received contracts. And there's no basis for it. So we think that the classification that's established there doesn't satisfy the Vermont Constitution because there's no basis.
All right. Thank you. Thank you both very much. Let's conclude the hearing now, please.
The next hearing for the court is scheduled for
Thank you.
1:30 this afternoon.
Your Honor.
Thank you very much.